All right, I think we can go ahead and get started here. Good morning or good afternoon, depending on where you're at. Hello and welcome to our webinar panel discussion of the Clean Water Act Section 404 Nationwide Permit Program, Permit 12, and a summary of the Montana court's decisions, how the Corps is responding, and what you can do for your projects. Just a couple housekeeping items before our panel gets going. The webinar is being recorded and we will make it available online afterwards. You will receive an email with a link to that, so keep an eye out for that email in a couple days. Please note that all of your microphones are muted and will be throughout the webinar. We have also disabled the chat function, but we encourage you to submit questions via the Q&A function. You should be able to see that in your Zoom toolbar. We do have time at the end when we will get to some of your questions. Just briefly, today I'm Cara Bellavia. I'm a Vice President with SWCA, and Ken Hauser, also a Vice President with SWCA. He and I will be moderating this webinar. And we have 4 awesome panelists. We have Noah Greenberg, a permitting specialist in our Denver office, Rick Howard, a permitting specialist in our Houston office, Alan Glenn, an attorney with Smith Robertson, and Scott Dethridge, an attorney from S. Dethridge Law. Just real briefly, our agenda includes a brief background on the Nationwide Permit Program, and then our panel will field a bunch of questions from Ken. And as I mentioned a minute ago, we do plan to have time at the end to answer some of your questions. So again, please submit any of your questions in the Q&A box, and we will get to as many of those as we can at the end. If we don't get to your questions at the end, we will definitely follow up, make sure your questions are answered. So with that, I'm going to hand it over to Noah to give us a little background.
Thank you, Cara, and thank you to everyone who's attending today. It's a pleasure to be able to speak with you about this regulatory development. We're going to go through just a brief background on Clean Water Act Section 404 and the Nationwide Permit Program, and specifically Nationwide Permit 12. And this is just to help support the conversation we're going to be having over the next 45 minutes to an hour. We'll talk about what is Clean Water Act Section 404. We'll briefly discuss the Nationwide Permit Program and how the Corps of Engineers uses that. We'll discuss Nationwide Permit 12 specifically. And then we'll start to talk about the basis for the Montana court orders that vacates Nationwide Permit 12, and that will be a part of the panel discussion that we'll be having. Next slide, please. So Clean Water Act Section 404, this is one of the sections of the Federal Clean Water Act, and Section 404 prohibits the discharge of dredged or fill material into waters of the U.S. unless the activity is specifically exempt or authorized under Section 404. Under Section 404, most discharges of material into waters of the U.S. require authorization, and that authorization is typically obtained from the U.S. Army Corps of Engineers unless the delegation to authorize activities has been given to states or tribes. The diagrams below provide a typical cross-section through a forested wetland, and they show the life cycle of a common pipeline activity. On the far left, you can see that there's a forested wetland with a high groundwater table. Then moving to the right, you can see that this forested wetland has been slated for a pipeline installation. There's been a temporary right-of-way and a permanent right-of-way established. And those areas have been cleared of vegetation. And if that clearing occurs using hand tools and equipment that doesn't create any ground disturbance and all the clearing occurs above ground, that is still not a Section 404 regulated activity. It's not until you look at the third photo image where you have heavy equipment operating and excavating and then disposing side cast materials into waters of the US that you have a Section 404 regulated activity. And typically pipelines will be installed and then the ground can be returned to their pre-construction elevation. And something that I want to highlight looking at the far right versus the far left photo is that upon completion of the pipeline installation project, the right-of-way can be allowed to revegetate, but typically woody vegetation and trees are not allowed to develop over the permanent right-of-way. And that's a necessity as a result of maintenance requirements, inspection requirements, and also pipeline integrity. Now, even though the wetland here has been converted from a forested wetland to a scrub shrub wetland, the Corps of Engineers would typically not consider that a loss of waters of the US for the purposes of the Section 404 permitting program, but rather a conversion of wetlands. Cara, next slide, please. So to provide a rapid authorization process for many small activities, the Corps of Engineers maintains a nationwide permit program. And this is maintained by the Corps so that they don't have to go through the permitting and administrative tedium of processing individual permit actions for every small project that occurs. Most nationwide permits allow no more than 1/2 acre loss of waters of the US, and there's a threshold where the projects should have no more than minimal adverse environmental effects. And so when the Corps of Engineers is issuing nationwide permits or authorizing activities under them, they're often comparing the proposed activity to those thresholds among many others that can be established on a national or regional or state basis. The nationwide permits are reissued at least every 5 years. The current nationwide permits were issued in 2017. They're not set to expire until 2022, although they may be reissued this summer in response to an executive order encouraging reduction of regulatory burden for many energy projects. So the nationwide permits that we're working under now may be replaced ahead of schedule this summer. One important thing about nationwide permits and the reissuance that occurs every 5 years is that National Environmental Policy Act review occurs during the reissuance so that that review doesn't have to occur for each action that the Corps may authorize under those nationwide permits. And the National Environmental Policy Act review, it includes measures to promote compliance with other environmental acts, such as the National Historic Preservation Act or the Endangered Species Act. Next slide, please. So one of the more than 50 nationwide permits that were reissued in 2017 is Nationwide Permit 12 for utility line activities. And utility line activities can include oil and gas pipelines, overhead transmission lines, potable water supply lines, sewer lines, and any other pipeline or transmission line that's a linear project. Nationwide Permit 12 authorizes the loss of up to 1/2 acre of waters of the US for each crossing of a single water body at a specific location for linear utility projects and their appurtenant facilities. Now, its losses do not include temporary impacts that can be restored or converted areas where you perhaps had a forested wetland that was converted to a scrub shrub wetland. It's also worth noting that the Corps of Engineers has a unique approach for linear projects under Nationwide Permit 12, but also Nationwide Permit 14 for linear transportation projects. And this approach for linear projects facilitates authorization for larger projects that cumulatively may have losses of more than 1/2 acre of waters of the US. And the diagrams in the lower portion of this slide depict that. For nonlinear projects, we could look at the black rectangle, and that might be a commercial building. And the 2 green circles would be wetland areas. And at one of the wetland areas, there would be a 3/10 of an acre loss of waters of the US. And at the other wetland area, there would be 4/10 of an acre loss of waters of the US. Cumulatively, those losses exceed 1/2 acre of waters of the US, and that project would not be eligible for nationwide permit authorization. If we contrast that with the image on the right, which shows a typical linear project with the dashed line being perhaps a pipeline, and the 2 green areas are wetlands that are waters of the US. And at each one of those wetlands, there would be a permanent loss of 4/10 of an acre of waters of the US. The Corps of Engineers will assess each of those losses independently with respect to the 1/2 acre threshold. Thereby, that project could move forward potentially under Nationwide Permit 12 because there isn't more than a 1/2 acre loss at each single incomplete crossing. And this approach for linear projects is what allows interstate, pipeline, and transmission line projects to move forward that may have cumulatively many acres loss of waters of the US, provided that each independent crossing complies with the thresholds that apply to Nationwide Permit 12. And with that, I think we can move into our panel discussion and specifically speaking about some of the legal considerations regarding the Montana court order.
Very good, thank you, Noah. Good morning, everyone. Yes, I wanted to start out with that very last example you used there, Noah, of a pipeline is what sort of started all this kerfuffle. Maybe about a month ago now, back on April 15th, or tax day, or what was tax day, nearly a month ago now, there was a court order that came out on a pipeline project in Montana. And I want to start with you, Alan. Welcome and thank you for joining us today. What did that court order originally say back then, about a month ago now?
Thanks, Ken. It's a pleasure to be here. So this is a federal district court in the state of Montana. It's the senior or the chief judge of that district. And it was one of the many cases going after the Keystone Pipeline. Among the various challenges that were brought by the Northern Plains Resources Organization and other non-governmental organizations was what you call a facial challenge to the application of this nationwide permit 12, which Noah so ably described. The background on that is in the past, the service has, the Corps has issued these nationwide permits on a 5-year rolling basis. And each time it has done so during the 2000s, at least up to 2012, it did conduct a programmatic consultation under Section 7 of the Endangered Species Act with the Fish and Wildlife Service. With the 2017 nationwide permits that Noah mentioned, the Corps elected not to conduct that consultation. That was a conscious decision on their part. It was, in my knowledge, based on, to a large degree, that they had adopted long ago, and they had modified further, General Condition 18 that applies to all of the nationwide permits, not just to nationwide permit 12. And it says that if an applicant has any idea that there is a listed species in the vicinity of one of these separate and complete crossings, or that might be affected by that separate and complete crossing, then notwithstanding the acreages or whatever, if it's going to go under the nationwide permit, that applicant must notify the district engineer of the Corps and wait until the Corps says it has discharged its obligations under Section 7. So what the Corps was thinking back in 2017, and I think the Fish and Wildlife Service knew this as well, is we have a safeguard in place such that nationwide permits as a whole, and nationwide permit 12 in particular, will not result in appreciable adverse effects on listed endangered and threatened species, because we have the backstop of this operation of the General Condition 18. The attack, therefore, by Northern Plains Natural Resources was, you should, Corps, have done a consultation at that time when you adopted these nationwide permits, what's called a programmatic consultation, not with respect to a specific project, but to the program as a whole. And the failure to do that was illegal and should result in the Corps being sent back to the Fish and Wildlife Service to conduct this programmatic consultation. So that was the basis of the attack. Now here, Ken, to answer your question, what the Corps said, what the court said, is that, you know what, you're right, plaintiffs, they failed to conduct a programmatic consultation. That's a fatal defect. And I am going to enjoin the Corps' use of that nationwide permit 12 without any mention of the geographic scope of that, so presumably nationally, until the Corps does go back and does a consultation under Section 7 of the Endangered Species Act with the Fish and Wildlife Service. It sounds like a bunch of acronyms and details, but I imagine to many of the audience, this is a huge problem, a huge deal, and lots of people got concerned about it very quickly. But that is in essence what the first opinion of the court said, is that we are sending you back to the drawing board. Now, Judge Morris enjoined the verification of nationwide permit 12. He did not speak to any other of the other nationwide, and there's a couple dozen of them, 3-4 dozen of them. But the implication is also there for those other permits, and we'll get into that later. Ken, thank you for the question.
All right. Well, thanks, Alan. That's great. And so you're right. That really did stir the pot, and a lot of confusion. from outside the Montana district, other district cores beginning to wonder what was going on. And they got a lot of pushback and a lot of action happened over the preceding 3 weeks. And just last week on the 11th, there was another court order. He came out and amended that order, basically saying, Scott, I'm going to ask you this question, basically saying, look, I was right, but okay, let's just enjoin it for pipeline projects, new pipeline projects, because there's a whole lot of grousing going on out there. So can you give us a little more color on that, Scott? What happened last week with that order on May 11th?
Sure, Ken, and thanks again for SWCA for inviting us to participate in this program. I think it's an interesting order and certainly has significant impact on a lot of industries. What occurred is, just first, what did the court do? In essence, the court cut back the approach and extent and scope of the April order, and it limited the order to dredge and fill activities for construction of, and I'm going to emphasize the term new, and then emphasize the terms oil and gas pipelines. So he said, I'm going to cut back my order, and it's only going to apply to new oil and gas pipelines that would be authorized under Nationwide Permit 12. And so it really cut back, allowed the nationwide permit to be used, but because of the nature of the lawsuit, which I'll discuss in a minute, the court agreed that it could cut back and only apply it to the types of activities that were really before the court, namely oil and gas pipelines. Now, as people like us, consultants, in-house people, and lawyers, we focus on words and what do the words mean, right? So one of the questions is, well, what does new mean? New could be a new application. It could be a new issuance of a permit. Could be a new pipeline, meaning not yet constructed. And here the court wasn't entirely clear. It used some fairly general and vague terms. So in trying to figure out what new means, I think we can look at the fact that the court cited existing pipelines when they talk about some of the things that could go forward under its ruling. And so we sort of have the new meaning not existing, and that's about all the guidance we have at this time. So so that's what's prohibited under the amended order. So what is allowed under that order? First, certain oil and gas pipeline activities can go forward under the permit. Those are routine maintenance, inspection, and repair activities for existing pipelines, meaning, I assume, ones that are already constructed. So I guess the court decided that it could limit its vacature and injunction as it saw those not being entirely that impactful on the environment or endangered species. The next area that opened up has to do with non-oil and gas pipeline activities. The first part of that would be electricity, transmission lines, solar and wind projects, which are in high gear these days in the US, particularly here in Texas where I'm located, or natural gas plants, other generation. So anything that has to do with electricity would not be barred. And then any communications lines such as telephone, cable, internet, fiber optic lines, none of that would be affected. And then interestingly, one of the things I thought of was, since it cites oil and gas pipelines, are there other pipeline projects that could potentially go forward? And for some of our audience, this may be important. So arguably a water pipeline, a wastewater pipeline, some other material, if there were a hydrogen pipeline or maybe a chemical pipeline, those apparently are not going to be prohibited under the court's order. One of the other things I thought of, because I've worked on refined product pipelines and terminals, is a refined product still considered oil and gas? I don't know if we know the answer to that, but that is an interesting question. So the next question in my mind is, well, how did this come about? How did the court get to this amended order? And I think it's interesting how that happened. The way it happened is the Corps of Engineers and the pipeline defendants filed a motion with the court to stay its order until the parties could go through an appeals process through the Ninth Circuit Court of Appeals. Interesting, the Corps said, we think you should totally stay the order, but at a minimum, you should stay the order as it applies to anything other than this particular Keystone pipeline project. Now, of course, the pipeline defendants argued the entire order should be stayed during appeal. Now, the plaintiffs in response said, look, we're willing to agree to and support with the court a narrowing of the order to new oil and gas pipelines. And ultimately, that's, of course, what the judge went with, because at least the parties were in agreement that that was a further limiting of the order. And so that's what the judge, in essence, did. So I think that's the general answer to question 2.
Yeah, thanks, Scott. So then you kind of touched on this a little bit, but what's kind of next steps then? Are the next steps in litigation regarding this particular order in Nationwide 12 ruling?
Well, in litigation like this, if you don't win in one forum, you always try to figure out what's the next forum. And so the Corps and the defendants, the industry groups, have all filed motions with the Ninth Circuit Court of Appeals. They filed emergency motions seeking a decision by the Ninth Circuit Court of Appeals, the appellate court, for that court to stay the district court's order until the appeals process could run its course. And just real quickly, the test for that, just to give the audience some idea of what is the likelihood of that being granted, there's a 4-part test that the U.S. Supreme Court has come up with. And so the first step is you have to show, as the applicant for the stay, that you're likely to succeed on the merits. In other words, you're likely to win. Then you have to show that as an applicant for the stay, you will be irreparably harmed. And you have to, in the third part, you have to discuss any substantial injury to the other parties. Here are the plaintiffs claiming injury to endangered species. And then the fourth part of the test is you have to discuss the public interest and where that lies. And so that will be the test at the Ninth Circuit Court of Appeals. There have been some people say that's not likely to occur if you read the Ninth Circuit Court of Appeals decisions in the past on similar rules, but we'll have to wait and see. So if the Ninth Circuit does not agree to a stay, there's a possibility that the parties can try to go to the U.S. Supreme Court and get a stay, arguing the same issues. And if that doesn't work, then the parties are left with the slow appeal process in the Ninth Circuit Court of Appeals, which could take, let's say, up to a year. So we may not have a decision out of the Ninth Circuit until next year. And then if the parties want to appeal that decision, whoever loses or isn't fully satisfied, then they could seek a petition with the U.S. Supreme Court and take it up to the big boys and girls in the D.C. court at the U.S. Supreme. So that in general is the process that the parties would go through from here on out.
Very good, thanks. So this litigation train seems to have left the station already. There's a lot been going on in the last month with the newer navigable water protection rule, this thing happening, I think the same day back in April, and all these other cases happened. I'm going to go back to you, Alan. What is the other litigation that's already taken place in the last month to 6 weeks that have been revolving around all these Corps of Engineers rules changes?
Yeah, Ken, I think there's been multiple cases that have now brought this issue in. I'm going to touch on one that I'm familiar with, and SWCA is as well. So, you know, this injunction hits, and there's really two questions that an industry or a company has to ask itself. The first is, am I affected by the injunction, and how am I affected by the injunction? But the second is, am I affected by the ruling? Because what it also does is open the door for litigants to come in and bring a new claim based upon the ruling that there was no consultation, and essentially invite their judge, in whatever case that may be, make the same ruling. So what I'm going to mention here is, as other litigation, has both of those factors in it. There is a natural gas pipeline intrastate, but Texas is so large where it is that it's you know, over 400 miles and it's still intrastate. It's called the Permian Highway Pipeline, and it's had its share of controversy. It's a 42-inch natural gas line going from the Permian Basin over to the Gulf area. And it did go through the consultation process. It is utilizing Nationwide Permit 12. There was a pending case in federal district court here in Austin, Texas, that was a bit of a kitchen sink approach to claims, but they had not brought something relative to the facial challenge to Nationwide Permit 12. They have now. So what that group of plaintiffs did once they saw the ruling is they amended their complaint to include a claim based upon the vacature of Nationwide Permit 12. So they weren't directly asserting that the court make a new decision, but that it honor the vacature of that and say that the pipeline no longer is operating under a valid permit. So this is, as I said, under construction, right in the heart of construction right now, different stages of construction all over the pipeline route. The other thing that happened, so that's one category. The other thing that happened is the Sierra Club, who was also involved in the Montana case, brought a completely new lawsuit in the same court in the Western District of Texas in the Austin Division. And that new case specifically seeks to put effect of the vacation on this project. And it sues only the Corps of Engineers. It doesn't sue the Fish and Wildlife Service. It doesn't sue the applicant, which is an entity called PHP. It sues the Corps of Engineers, and the relief it is seeking is an injunction that would have the Corps withdraw all approvals for this approximately $2 billion piece of infrastructure that's currently under construction. Other than the complaint that they have filed in this case, because the government's answer has not yet come due, nothing has happened with respect to that claim. I think everybody is watching where this issue now gets brought in other jurisdictions. The other thing to keep in mind, though, too, is that while the injunction as amended applies to oil and gas pipelines, the ruling applies to anything that could be authorized under any of the nationwide permits. So those who are involved in electric utilities or state departments of transportation, you're just one lawsuit away, or one amended complaint, as we had in the Permian Highway case, away from having this issue front and center in your project, in your case. So it's definitely, the implications are much broader than oil and gas and broader than Nationwide Permit 12. Obviously, as Noah mentioned, 12 and 14 both deal with linear projects, one utility lines and the other transportation projects. And they are very, very similar authorizations. So I am particularly concerned about plaintiffs who will seek to expand the effect of the ruling to Nationwide Permit 14 as well.
All right, so I want to talk a little more, I guess, about other projects that are under construction now, or what does this mean to projects starting the permit process now? Maybe I can jump to that. Projects that are about to get approved first, and maybe ones that are thinking about getting in. There's been a lot of permit activity. We see this still, given everything going on, still people applying. Maybe, Noah, can I get to you on this question about what does it mean for projects that are about to get approved?
Yeah, thank you, Ken. You know, for projects that are about to be approved, if they fall into the category of actions which the Corps of Engineers is prohibited from authorizing under Nationwide Permit 12 under the amended order, there's a couple of things that permittees or project proponents could be looking at. They could be looking to potentially avoid the need for Section 404 authorization. And that could be achieved perhaps through design modifications to the project, such as using directional bores to go underneath waters of the US rather than open trenching through them. They can also look at the potential for getting an approved jurisdictional determination, whereby perhaps the wetland or non-wetland waters that would be impacted by the project are eligible as non-jurisdictional features under the current regulations or under the Navigable Waters Protection Rule, which is expected to be implemented in mid-June. Alternatively, if a design can't be modified to avoid impacts to waters of the US and an approved jurisdictional determination won't result in a favorable non-jurisdictional determination, applicants can then explore alternative authorization measures. There are other nationwide permits that may be available for the activity. For example, I've seen Nationwide Permit 39 for commercial and institutional development used to authorize pipelines that are associated with well pads. So if you have a pipeline that's in close proximity to a well pad and the pipeline is needed to support that well pad's operation, that pipeline may be eligible for authorization under Nationwide Permit 39. Similarly, for residential development under Nationwide Permit 29, if there's water or sewer lines that are associated with that, whereas historically we would have typically used Nationwide Permit 12 to obtain authorization for those activities because it may have lower notification requirements, permittees could still go forward under Nationwide Permit 29 with pre-construction notification to the Corps of Engineers for those water or sewer lines associated with their residential development. Finally, although it's got a long timeline for preparation and review, individual permits are always an option for projects that need to move forward. And we can always look at what is entailed with the individual permit application and review process. And some Corps of Engineer district offices are able to process individual permits in roughly 6 months, which may not be a schedule killer for many large utility projects. So there are options to look at in the meantime while Nationwide Permit 12 and this court order gets sorted out.
Now, not that we advocate for going to from a nationwide and individual permit, no, but what would the Corps literally do that if you had a project that otherwise qualified for a nationwide permit? They entertain going to an individual because of this confusion around this situation right now?
That is one of the options that's available. And so if the Corps of Engineers is unable or unwilling to use another nationwide general permit or regional general permit to authorize the activity, and Section 404 authorization is required for the project, then an individual permit would be the most likely route for that. And the decision as to whether or not to wait for Nationwide Permit 12 to become available for the project or to proceed with an individual permit application, that needs to be done on a case-by-case basis for each project, taking into considerations such as project schedule, budget, and the perceived complexity of obtaining an individual permit for the action.
All right, well, thanks. That's good clarification. Rick, you're in Houston. I want to go to you next and ask you some specific questions about the impacts of this stuff in real life. You've got hands on a lot of projects, you interface with a lot of clients every day down there. What's the impact of the pending Navigable Water Protection Rule that's out there due to go into effect next month, pending all this litigation? And how is that sort of influencing your decisions and the risk analysis you're helping your clients do when it comes to using these nationwide Permit 12 program?
Yeah, thanks, Ken. I really appreciate it. I think one of the biggest things that we see with the Navigable Waters Protection Rule is the fact that it's creating a great deal of uncertainty. The timelines are a little odd in that we're expecting this law to roll out and that the Navigable Waters Protection Rule take effect in June. But we also, I think I can get a big head nod from our lawyers here when I say that it's probably going to be litigated out the wazoo as soon as it is made rule, because we know that we already have several challenges to it. Several states have already started to issue suit about the WOTUS ruling. So I think in essence, it's one area where I've been dealing with a few clients who are looking at filling waters that would be non-jurisdictional once the navigable waters rule is made law. But I'm cautioning them to be very conscious of the fact that the litigation over it may preclude the use of the assumption that those are non-jurisdictional waters. So it kind of goes back to what Noah was saying just a second ago, is that it may behoove the client, depending on what the project is and what their timelines are, to sit back and see how that settles. That said, it's very likely that the Navigable Waters Protection Rule will take quite a while to settle out. So for most of those clients, I'm trying to encourage them to look at the nationwide permitting program and see what can apply. And I think Noah did a great job of covering that, but there's one little piece that I would add to that, and it's just the fact that we have to be really cognizant of what nationwide permits are available for each project by location. Down in the Galveston district, nationwide permit 51, which is usually used for onshore renewable energy projects and that sort of thing, is not allowed by the Galveston district. So projects that would normally be running under nationwide 51 in most districts, or nationwide 12 in the Galveston district, suddenly find themselves with no great option but to avoid or to redesign their project to meet the requirements of the nationwides. So it creates a lot of chaos and a lot of uncertainty that is not what anybody wants, especially the consultants and the clients that are trying to move their projects forward. So I think the WOTUS ruling is going to create a lot of problems, and it's something that as you're initiating your projects and you're starting to kick off, that you make sure your project engineers are aware of, that you make sure that your clients are recognizing the potential risks to the project itself in terms of timeline.
All right, I want to, maybe you kind of jumped ahead of me and got into this question already. What does this mean for projects that are starting? Clients that are contemplating projects now, maybe you or Noah can take a crack at that. You kind of covered that, talking about other options, but that might have been people that were working on permits or projects already. People are thinking about it in terms of a risk evaluation, a risk analysis of where things are at, given the litigation coming. Any thoughts from any of you guys really on what does this mean for projects that are thinking about entering the process now? Noah, anything from you?
Yeah, to me, this highlights one of the the top recommendations I provide to clients and permittees, which is to coordinate early with the Corps of Engineers. My experience working with the Corps is that they are typically looking for ways to find authorization opportunities for projects. And so through early coordination on your upcoming projects, you can work through some of the different scenarios that may apply to the project when it actually comes time to go to construction or submit your permit application. And you can look at what are the possible scenarios for Nationwide Permit 12, and can this legal stay of Nationwide Permit 12, is it expected to be lifted by the time the project needs to move forward? Or is the Corps of Engineers willing to use another nationwide permit to authorize the activity? And so my bottom line is that this is an especially good time to coordinate with the Corps, because each Corps of Engineers district office may have a different interpretation of which nationwide permits are available and what activities they can authorize under Nationwide Permit 12, even while this Montana court order is still in effect.
All right, good answer, thanks. So what about this program? moving forward with the core, Scott and Alan, I'm going to bounce back to you, because what does this mean for the whole nationwide permit program? There's all 51 of them or whatever there is. Doesn't this sort of open the door for folks to look at the same issue with all the other programs out there? And do people need to be worried about this sort of migrating to, you mentioned earlier, 14 or 33 or any of the other programs we commonly use? Alan, maybe I'll start with you.
Sure, thanks, Ken. I think as long as that order is out there, which could be, it could be stayed by the Ninth Circuit, but you know, as Scott said, it could also be a year if it's not stayed by the Ninth Circuit and we wait for the Ninth Circuit to rule on the merits. During that period of time, essentially anyone using any of the nationwide permits has to assign some level of risk to the possibility that they will be challenged on the use of any of the nationwide permits. But I think the key aspect of this is if I'm the Corps and the Fish and Wildlife Service, I just had a federal judge told me to do a programmatic consultation. That's what I'm going to do. I've done that in the past. I'm going to do it again. And I think that's where, for people who aren't, you know, trying to resolve this issue immediately, that's where the game is really going to be shifting, is what will the agencies do to satisfy this programmatic consultation requirement? As everyone knows, this is a massive, massive program, and you can't really consult on an individualized risk analysis, threat analysis for all of the domestic listed species. So in the past, with the, as I mentioned in my opening remarks, what the Corps has done is used General Condition 18 as essentially a catch-all to avoid impacts to listed species that would otherwise require formal consultation, and to ensure that if formal consultation with under the Endangered Species Act is required, it will occur. So what the two agencies come out with when they go back into programmatic consultation, which I presume is a high priority for them now, is going to be all important. Is General Condition 18 going to be like it is? Are there going to be more requirements associated with it, more deliverables? You know, one of the things that has creeped into this process is where you've got a linear project, and because of General Condition 18, you are providing the Corps pre-construction notification, and they're going to then verify your authority under Nationwide Permit 12. You know, once they do that, I'm sorry, I lost my train of thought. Go ahead, Scott, take it over there.
Well, go ahead, Scott.
Yeah, I agree with Alan. I think just to some extent, the situation the Corps and sort of innocently, if you will, the permittees find themselves in is a bit of an unforced error by the Corps, wherein the Corps had in the last two prior nationwide permitting procedures gone through a programmatic review under Section 7 of the Endangered Species Act, but chose not to in the last process. And, you know, all these agencies are pushed in one way or another, whether it's the EPA or the Corps or the Fish and Wildlife Service or what have you, based on the politics of whatever administration is in effect. And so they get sort of pushed in one degree or one direction or another. I think we need to think about not only the nationwide permit system as it exists today, but the system's going to be reevaluated and reissued, I guess, for what, 2022. And so is the Corps going to try to save the existing nationwide program, or simply turn to the next round and try to deal with these issues up front, and hopefully avoid at least individual challenges that we saw in the Montana District Court? Now, there may be environmental groups complaining or suing over the next nationwide permit system and its impact on endangered species, but at least the program's going to get through somehow. And when we're not hopefully going to be facing these questions on individual pipeline or other projects. I mean, that's at least the hope. Now, they may be able to challenge impact on an endangered species in any particular project, but if they're not challenging the entire program, maybe it just doesn't gum up the works because, as Alan said, I think others have said, this is such an important part of the permitting program for wetlands in particular, that, and it's been around for decades, it really is a way of trying to protect the environment, but making environmental programs efficient and timely so that business can be done and everything's not held up. So it really is an important program. Hopefully the Corps will be able to deal with it, at least in the next issuance of the nationwide permits.
All right. Well, thanks. So, Cara, get to our next slide. I think we have the last question up here was about gauging risk. If you're not covered by any of these specific orders, how do you proceed? I think we've touched on that largely with the panel. So maybe I could switch to some of the, thank you folks for sending some questions in. We got a handful of question and answers. Remember, you're muted and your chat's not working, but the Q&A button at the bottom there is open. If you guys want to type some questions in there, send them our way. We have about 15 or 12 or 13 minutes left here, and we'll try to get to some of those next. Because unless there's anything you guys want to say about this question here we put together for risk, gauging risk around this specific order, I think we touched on that pretty well. We all good?
Yeah, let's move on to the audience questions.
Okay, there was one interesting one that I don't know the answer to. I want to put up there for Noah about nationwide permit 33. Is that something that can be used or considered as an alternative, particularly for oil and gas pipeline stuff?
Yeah, Ken, thanks for that question. And that question actually is similar to some of the other questions we've received. For example, can nationwide permit 18 for minor discharges be used? But back to the original question, nationwide permit 33 is for temporary access and construction and dewatering impacts. And that is a nationwide permit that I would encourage pipelines to look at, especially if there's not permanent impacts to waters of the US. So for example, if the project impacts will include temporary excavation, installation of a pipeline, and then refilling and returning to the ground to pre-construction conditions, I absolutely think that nationwide permit 33 would be worth exploring for that activity. I also would encourage people who perhaps in the past have gotten pushback from the Corps for using nationwide permit 18 or some of the other nationwide permits for their utility line activities to revisit those conversations with the Corps, because my experience with the Corps of Engineers is that they will often encourage you to use the nationwide permit that is available and best describes the project purpose. And for pipeline activities, heretofore, it's absolutely been nationwide permit 12 would be the most appropriate nationwide permit for that activity. But now that nationwide permit 12 isn't available to authorize these activities, I believe that the Corps has the discretion to use other available nationwide permits that could be available and authorize pipeline activities to move forward.
All right, good to know. Rick, I'm going to bounce back to you. We had a question earlier on today about linear versus nonlinear projects. Right? Some might have both features. How do you anticipate those things getting addressed in this environment?
That's a good question. I had a very similar project a couple of years back that we were able to permit under nationwide 12 by demonstrating that we had independent utility for the linear portion compared to the nonlinear portion. It was basically two substations connected by a transmission line. And so it's possible that you could permit those both as separate tasks or separate objects within the greater project goal. So by divorcing those apart, that can give you some latitude to move forward with certain portions. I don't know how that would work in the oil and gas arena right now, since there's a specific call out for oil and gas projects to not be allowed under nationwide 12 right now. But that's one way that you could address it if you have components that you think would push you over a total limit. Say you have a transmission line that you need to replace or route, and you have a separate need for the substations to serve them, then you could possibly move forward with the nationwide 12 on the transmission line, and then move forward with the substations separately as separate and complete projects. That's a good system or a good way of moving it forward and keeping in line with a timeline that might otherwise be getting quite tight if you had to go with an individual permit. So I think that's a one possibility in the current climate.
All right. There's another one here. I lost it now. I was going to ask you, Alan, about something. Now I missed my.
I can give you Ken. It's, will the upcoming nationwide permit reissuance include programmatic Section 7 consultation?
Yeah, that's a good question. I think the answer is probably yes. I think a lot of us lawyers are wondering about the decision not to conduct consultation last time around. And I noticed one of the other audience members asked, did they in fact conduct consultation in 2012? And I'm pretty sure they did. So I think the new nationwides will come out with a consultation. It's possible that one will happen before then. And in either event, it's really going to be important to have some influence over what the conditions are that are adopted as a result of that consultation. I do think that there's an irony here, and I'm holding some hope out for the Ninth Circuit, and that's that one of the major pipeline cases of interest other than Dakota Access in the last few years was a case involving Enbridge's Flanagan South Pipeline, and it was ultimately ruled on by the District of Columbia Court of Appeals, Federal Court of Appeals in District of Columbia. And it essentially said, when you have a large pipeline project like this, and you have all these little nicks of jurisdiction from the Corps, that does not take a fundamentally private action and turn it into a federal action requiring to end NEPA review or Section 7 consultation. The NEPA review is what they focused on. So you really had the court, a sister court to the Ninth Circuit, come down strongly that this is a system that is not intended to federalize these projects, and yet on the basis of an error, alleged error in that system relating to non-federal projects, they're all stopped as if they were federal. So in an ironic way, this very much more affects intrastate gas pipelines and crude lines everywhere, while if you're already having to go FERC because you're an interstate gas line, it probably is not as big an issue because you've got the whole federal penumbra over you anyway. But to answer the question again, yes, I think they're going to have a consultation on the new round of nationwide permits.
Learned their lesson, hopefully. All right, I have another one here, maybe for Noah or Rick. What does maintenance repair only include? Lifetime projects? For example, can a pipeline replacement be offset in the right of way, such as the pipeline being lowered? Rick, you want to tackle that?
I can give it a crack. I think in the case of the maintenance nationwide 3, you've got the ability to work within your right of way as long as you're not making substantive changes to what was previously issued or previously permitted. So I would think, and Alan or Scott might be able to chime on this as well, that would not fit in under a new project, but rather a replacement, since you're not like looping a pipeline or something like that. I think that it should be something that would be admissible under Nationwide 3, since it will allow you to replace something that was previously permitted, assuming that it was previously permitted. There are projects that predate the nationwide permit process, and those may not have ever had a nationwide or an individual permit associated with them. So I would think that would be permissible. Noah, Alan, Scott, you guys would like to chime in? I'd appreciate it too.
Yeah,
Rick, the only caveat I would put on all of that is, as I mentioned, all of the permits are at risk. And at some point, the Corps is going to have to face a hard decision of, do they press pause on the program while they consult, or do they keep going through the nationwide permit program and end up having lawsuits filed all over the country over the use of other nationwide permits. But I mean, I think you're basically right that it would qualify, but again, I think there's a point at which the Corps is going to say the burden of self-inflicting all of these lawsuits by continuing to verify under the nationwides outweighs the benefit of keeping them in place. Let's just fix the problem as soon as we can and put a stop on everything else.
All right, guys, we have about 4 minutes left or so to the top of the hour. I want to make sure we respect everybody's time. I'm asked the panel one last time, is there any other question in there that you piqued your interest? They're flying in here hot and heavy, and I want the audience to know that we're going to take a crack at trying to get back to you individually offline here. This will be recorded and posted. You'll get an email about that if you're an attendee today, so you can see the presentation recorded again. And we will do everything we can to get back to you on some of these questions. We've got a lot of them, but time for one last question. Anybody have any in there that they see that really would be pertinent for this group?
I might just comment. There are a couple of questions on. One is about water pipelines, and the other is, well, what is the Corps still able to authorize projects under Nationwide Permit 12? And I think if you read the court's order, its amended order, it only applies to new natural gas pipeline projects, and so anything that doesn't qualify as that is not prohibited. Alan raises an interesting question of what should or should not the Corps do, but to the extent a company wants to proceed under the existing order, legally they are allowed to do so. And the Corps is not enjoined, nor is the rule vacated with respect to anything but new natural gas pipelines. So, so I think, you know, to the extent parties have to move forward, there is still risk, but at least they can move forward if they choose to do so.
Very good. Thank you, Scott. Well, Cara, we're pumping up here on the top of the hour. Did you have any closing remarks as we want to sign off with this group?
Yep, I sent a note in the chat, so everybody should see that. I think you mentioned it already too, Ken, but we are recording this and we will send you an email with a link to the recording. And as we have mentioned and Ken noted, there's a handful of questions here that we definitely didn't have time to get to, which are great questions. So we will follow up with you all individually for those who we didn't get to. And if you didn't get a question in the Q&A chat box and you still have questions, I'll leave this slide up here as we close out. Here's the contact info or the email addresses for Ken and I and our panelists. So if you have any specific questions, again, I'll leave this up so you have their information and can shoot off any questions you didn't get posed. But other than that, just thank you so much for your interest and for calling in and your time and for asking these questions in this very interesting time around Nationwide 12 and related permitting.
And thank you to this great panel. You did a great job, guys. Thank you again for your time. And everybody have a great day. Take care and be safe.
Thanks, Ken.
Thanks for having us on.